Hi, my name's Steve Bartlett, and welcome to Fight Back. As you know, I love controversy, so today we're going to have a pretty controversial subject matter, probably the most controversial subject matter that there is. We're going to be talking about abortion. Now, the purpose of the show isn't to advocate one thing or the other. What I'm going to do today is try to educate you about what the law is concerning abortion, because most people don't really have a clue about what abortion rights are, or why we have abortion rights, what Roe v. Wade stands for, why it was decided, or what the legality of it is at this present time. So I want to go through an overview, at least during the next 30 minutes, about abortion. Okay? Now, before I start specifically about abortion, you have to understand the concept of fundamental rights. Because in our country, we all have fundamental rights. Now, people think that we get our rights from the Constitution, but we don't. Our rights transcend the Constitution. As proof of that, if you read the Declaration of Independence, the Revolutionary War was fought because our rights were being violated. Well, if you don't get your rights until there's a Constitution and a Bill of Rights, how could our rights be violated? Because these rights existed by nature or by God, which doesn't rely on a Constitution for them to exist. Okay? What are these rights? Well, the rights, according to Jefferson, were the rights of liberty, the right of life, the right of the pursuit of happiness, and also the concept that all men are created equal, the concept of equality. These are inalienable rights that we have as a part of nature. And if you read the Constitution and the Bill of Rights, it never says that we have a right to life. It never says that we have a right to liberty. It doesn't say we have a right to pursue happiness, okay? But we still have these rights. They're fundamental rights that we actually have. So that's where we get our rights from, not from the actual Constitution. Now, some scholars, like Justice Scalia, believes that unless a right is specified in the Constitution, you don't have that right. Therefore, if it doesn't say you have a right to have an abortion, you don't have that right because it's not in the Constitution. But our constitutional rights are not given to us by the Constitution for the most part. They exist in nature. Now, the history of the right to have an abortion goes to a previous case before the concept of abortion became something that we were declared to have that right. And that goes to a concept called the right of privacy in a case called Griswold versus Connecticut, which was written by a guy named Justice Douglas, who was they called him Wild Bill. He was in the Supreme Court longer than any other judge in history. And what happened is the state of Connecticut passed a law saying that it was illegal for people to use contraceptives in the state of Connecticut. And that went to the Supreme Court, and what Justice Griswold said is that we have fundamental rights even if it doesn't specify them in the Constitution, because rights come from nature, and there's implications that some rights imply the existence of other rights. And the one right that he found that is in existence is the right of privacy. Like, for instance, the government needs a warrant to get into your house. In order to search you, they have to have probable cause. Why? Because you have a reasonable expectation of privacy. So even though the Constitution doesn't say you have a right of privacy, you have a right of privacy. And what Justice Douglas said in Griswold is that that right of privacy is most fundamental when you have something going on sexually, you know, in your own body. And he said in Griswold that the right of privacy extends to the right to control reproduction. So therefore, it is unconstitutional for the government to say that contraceptives are illegal. Now, when a person has a fundamental right, the Supreme Court goes through a process called strict scrutiny. And how strict scrutiny works is the first step is the government has to find whether or not you have a fundamental right or not. Some things are not fundamental rights. The right to have a driver's license is not a right, it's a privilege. But the right of privacy is a fundamental right. The right of life is a fundamental right. However, these rights are not absolute. Anybody who thinks that your rights are absolute is fooling themselves. All rights have limits because the government has powers, and sometimes the powers of the government conflict with the rights of the individual. And what they use is the strict scrutiny test in order to do that, in order to decide whether or not you can exercise your right or whether or not the government has a right to regulate it or eliminate it. And if you don't believe that rights are limited, try to scream fire in a burning building. Try to call in a bomb threat. That shows limits to your freedom of speech. Freedom of religion isn't an absolute right. If you want to drop babies into a volcano and engage in human sacrifice because you're a card-carrying member of the Satanist religion, find out how long that argument lasts. Okay? You do not have absolute rights. You don't even have an absolute right to life. If you don't believe that, talk to a person who's on death row. Okay? The government has the ability to limit your rights in certain circumstances, and like I said, that's called the strict scrutiny test. Now, here's how strict scrutiny works. Once they've established that you have a fundamental right, in order for the government to limit that right or make it illegal for you to exercise that right, the government has to have something called a compelling state interest. There has to be a really, really important reason for limiting that right, and that there's nothing else that the government can do which is less intrusive other than making that right illegal if they want to promote that fundamental interest. So, for instance, when it comes to the First Amendment, there's a compelling state interest to stop a panic and people stampeding each other by someone yelling fire in a crowded building. So therefore, because there's that compelling state interest for public safety, they can eliminate your constitutional right to freedom of speech. That's how the strict scrutiny test works. Okay, so let's move on to 1973, which is the famous case Roe versus Wade. Now that you have this thing in context about how Griswold established the right of privacy when it comes to sexual matters, how there's the strict scrutiny test about compelling state interest, and whether or not the state has a compelling state interest, and whether that trumps the person's individual right or not. So in Roe v. Wade, which used Griswold versus Connecticut as precedent, Harry Blackmun found for the very first time in the very divisive Supreme Court case that women have a fundamental right to have an abortion, that the right of privacy, the same reason why you have a right to control the reproduction by saying I can take contraceptives and the state can't say I can't take contraceptives, Harry Blackmun found out that you have a fundamental right to have an abortion. You have a right to control the reproduction of your body. Women have that right. However, the government does have legitimate interests, and some of them are even compelling, which could possibly limit that right. And what Harry Blackmun did in the famous Supreme Court case of Roe v. Wade is he said that there's 3 different time frames that we have to pay attention to when looking at to whether or not a woman should have that right to have an abortion and whether it trumps the government's possibly compelling interest to limit an abortion. And that is based upon time. What Blackmun did is he divided pregnancy into 3 trimesters, each one being 3 months long or 12 weeks. So they're called the first trimester, where the woman's barely pregnant, the second trimester, and then the third trimester when the baby's ready to come out and ready to pop. So the last 12 weeks is a third trimester. And what they said is, well, let's look at each one individually. Let's look at the first trimester or the first 12 weeks. A woman has a fundamental right to control the reproduction of her body. She has that right. What is the government's interest? And according to Harry Blackmun, there is no government interest in the first 12 weeks. Okay? Why? Well, the government tried to argue, well, we have an interest in protecting the health of the mother. But under medical concepts, a woman's health is not in danger during the first 3 months of a pregnancy. She's more likely to die going full term and having a child after 9 months than she is dying during an abortion. So therefore, the government has no interest in making abortion illegal, since an abortion is safer than having a pregnancy. Women are more likely to die giving birth than having an abortion. So therefore, there is no government issue. There is no government interest in protecting the life of the mother during the first 3 months of the pregnancy. What about the life of the fetus? According to Harry Blackmun, a fetus is not viable during the first 3 months. Viability is defined as the potential to live outside of a mother's womb by itself, albeit with artificial aid. So you can put it in a little incubator, you can put the baby in some tubes and give it some medical attention, but the ability for a baby to live outside of the mother's womb, that is impossible during the first 3 months of a pregnancy. So therefore, there's no government interest in protecting the life of a non-viable fetus at this time. Okay, so according to the Supreme Court in Roe versus Wade, during the first 3 months of a pregnancy, a woman could have an abortion and there's nothing the government can do to try to stop it. Okay, the second 3 months of the pregnancy, okay, the baby's cooking a little bit longer. Now it's a little bit more dangerous for a woman to have an abortion than it is during the first 3 months, okay, and it's a little bit closer to being viable for the baby. Well, what the Supreme Court said is that during the second trimester, the government can make some regulations about ways to protect the mother because the mother's health is at par, but a child still isn't viable during the second trimester either. So therefore, there is no compelling state interest to trump the woman's right to have an abortion during the second trimester, even though they can make some regulations to protect the woman's health during her pregnancy. At that time, the government can regulate that. Okay. However, during the third trimester, things changed dramatically. And in Roe versus Wade, they said that in the third trimester, after 24 weeks, a child is viable, that the fetus is viable, and that a baby can survive outside of the womb in the third trimester. And therefore, there is a compelling state interest to protect the life of the baby at that time, because if it can survive, it is a baby and no longer just a fetus. And therefore, the government can not only regulate or restrict, but can completely outlaw all abortion if the government wants to during the last trimester. So for the first 2 trimesters, women can have an abortion. In the third trimester, the government has a compelling state interest to protect the life of the fetus and can make abortion completely illegal if they want to after 24 weeks. Doesn't mean they, after 24 Right, after 24 weeks, they can make it completely illegal if they want to. The government doesn't have to do it, but each state has the right to do that if they want to do that. Okay? And that's what the law of the land was throughout the 70s and throughout the 80s. But then in 1992, it changed. And it changed with a famous case called Planned Parenthood versus Casey. And in the Casey case, okay, everybody thought the Supreme Court was going to overturn Roe v. Wade and make abortion illegal. But what happened was 2 conservative judges, Justice Sandra Day O'Connor and Justice Kennedy, switched and took a middle ground, and they upheld that there was a fundamental right to have an abortion. However, they changed the test from strict scrutiny to something a little easier for the government to regulate. Okay, everyone thought that they were going to strike down abortion as being illegal. But these 2 conservative judges found that there was a fundamental right to have an abortion. Okay, but they replaced the strict scrutiny test, which required a compelling state interest, to something called the undue burden test, which meant that, that even though you have a right to have an abortion, okay, the government can't, and the government can make it illegal in the last trimester. Any other regulations besides that, the government can do as long as it doesn't place a quote-unquote undue burden on the woman's right to have an abortion. As a result of that, governments have been able to make abortions rarer than they were before that. States have been allowed to have parental notification laws requiring minors to tell their parents about their wanting to have an abortion and to even require their consent. However, that was considered to be an undue burden, unless there's something called a judicial bypass, which allows children to go to the judge and ask a judge to allow for the abortion. So as long as a state requires a parental notification and parental consent, but allows a child to go to a judge to get permission to have the abortion, that law would be considered to be constitutional because it's not an undue burden. Okay? Other cases have been upheld by the Supreme Court that may have been reversed as illegal because of this new change in the law. For instance, a law was passed that outlawed partial birth abortions. That law was upheld because it did not place an undue burden on a woman's fundamental right to choose whether to have a baby or not. It just prohibited a type of abortion, didn't prohibit all types of abortion, so it was considered to be a non-undue burden. Okay? In 2016, it went to the Supreme Court again about abortions. Now, this time we only had 8 people on the Supreme Court because the Republicans blocked Obama from putting somebody on the Supreme Court after Scalia died. So there's only 8 people in the Supreme Court. And what happened is Texas had a whole bunch of laws which really screwed with women's right to have an abortion. They created all these codes saying that women, for instance, could only have an abortion in places that met the same exact standards as a hospital, which closed down most places that women could have an abortion. So women would have to try 500 miles to be able to go to the nearest place where she could have an abortion clinic. It became almost impossible to have an abortion in the state of Texas. It was clearly an undue burden, okay, which would have been a violation of Casey and Roe v. Wade. Well, what happened is the Supreme Court agreed that this was an undue burden and struck down the law in Whole Woman's Health versus Helistech. in 2016. Okay? However, it was a 5-3 decision. 5 liberals on the court, or actually 4 liberals on the court, and Judge Kennedy were the 5, and the 3 people who were in dissent were Justice Alito, Chief Justice Roberts, and Clarence Thomas. So it was 5-3. Okay, so that law was struck down as being an undue burden. Okay? Well, let's look at the future of abortion rights. Let's see what's going to happen in the future. Well, the Supreme Court is not the same Supreme Court as it was in 2016. Okay? It was a 5-3 vote at the time. Kennedy's no longer there. So now it's a 4-3 vote if we take Kennedy out of the equation. But Kennedy was replaced by Neil Gorsuch, handpicked by Trump and also Brett Kavanaugh, 2 hardcore conservatives. In all likelihood, if that case were heard again today, it would be a 5-4 decision in favor of the conservatives, and there's a strong chance that Whole Woman's Health versus Hellerstedt would have a totally different outcome. That those judges would find that even if there is a fundamental right to have an abortion, that that it's not an undue burden what Texas did, and that the government can pretty much do almost anything, and making it really hard for you to ever say that it's an undue burden. Okay? Now, possibly Judge Roberts might take a more centrist position because he's somebody who's a traditionalist and doesn't like to overturn precedent that much. But since he's already dissented once in the 5-3 decision of Whole Woman's Health, in all likelihood, he would follow that same policy, and he probably would uphold that kind of restriction, and probably many other restrictions as well. One other restriction that's been talking about is that instead of making it 24 weeks where a woman can have an absolute right to have an abortion, what if we pushed it back to about 20 weeks instead of 24 weeks? Well, technology has changed. A baby wasn't viable back in 1973 at 20 weeks, but maybe a baby could be viable now at 20 weeks. If there could be scientific evidence showing that a baby could be viable prior to the 24 weeks, there's a strong probability that based upon that Planned Parenthood versus Casey decision, that the Supreme Court would uphold that kind of restriction as not placing an undue burden on a woman, because they could always say, hey, if you wanted an abortion before the 20th week, have the abortion. But after 20 weeks, that's reasonable for the government to have a compelling state interest because of the fact that a baby can be viable prior to the 24th week. So we really don't know what the Supreme Court's going to say, whether they're going to say, no, we're going to keep 24 weeks as a line in the sand, or whether they're going to roll it back because technology is making it easier for babies to live outside of the womb. Okay? So that's possibly where the future of abortion rights are going to actually be. Okay? But liberals are pushing back, and there's been a new statute that just passed in the state of New York, which prompted me to actually do this show and talk to you about this, which the conservatives are up in arms about because they're saying that it allows babies to be aborted up until the day that the baby is born. Now, according to Roe v. Wade, the Supreme Court said that in the 3rd trimester, a state could, if it wanted to, make abortion completely illegal. However, at the same time, according to Roe v. Wade, a state could, if it really wanted to, could make abortion completely legal up to the time that a baby is born, if they wanted to. They could actually say that you can kill a baby up until birth. The Supreme Court didn't actually say that, but that's what the implication of Roe v. Wade actually is. They never actually got to the point as to whether or not there's a fundamental right of life to a baby who is viable. And in that case, there's a really strong argument that could be made by conservatives that a viable baby after 24 weeks has a fundamental right to life, and therefore, even if the government wanted to make abortion legal up until the time the baby is born, that could be struck down as unconstitutional by saying that a baby after 24 weeks does have fundamental rights. That's never been argued, that's never been decided, but it would be a logical argument, because if a baby is viable at 24 weeks, that baby should be entitled to some sort of due process rights. I disagree with the conservatives who believe that any baby from the moment of conception should have a right to due process. But if a baby is considered to be viable, and therefore there's a compelling state interest to protect that baby, then that baby should have rights and should be able to get protections. So any type of law that does allow for abortions that allows abortion on demand without any restrictions after 24 weeks could be unconstitutional for a very different reason, for violating the right of the baby as opposed to violating the right of the mother. Okay? So what this law does in New York is basically it codifies Roe versus Wade by saying that the same decision in Roe v. Wade is what applies in New York, that women actually have this fundamental right to have an abortion. And what they did was, the first 2 trimesters are exactly the same, but the 3rd trimester is a little bit different. What happens in the 3rd trimester into this new New York statute is that it takes out the whole concept of criminal sanctions for having an illegal abortion. It's now considered to just be a medical health issue, that we're not going to regulate abortions as a potential crime. We're going to just look at it as a medical position, which, okay, I understand that doctors perform abortions. Let's take it out of the criminal realm. But what they do is they allow that women can have abortions in the 3rd trimester under certain circumstances, okay, in the state of New York. One circumstance that a person can have an abortion in the state of New York is if that baby, even after the 24 weeks, is not viable. And that makes sense, because if the baby's not viable after, let's say, 40 weeks and is basically stillborn and dead, there's no compelling state interest to protect the life of the fetus if the fetus still isn't alive. If the baby can't live outside of the womb after 24 weeks, it's the exact same situation as if the baby couldn't live outside of the womb before 24 weeks. It's a non-living baby, and therefore there's no compelling state interest to protect it. So what they do in the state of New York is they basically say that if the baby isn't able to live outside of the womb after 24 weeks, a woman has the right to have an abortion, which is pretty similar to what the law is right now anyway. Okay, so it's not really changing anything that much if you're able to protect the, if the baby's not viable. What are you hurting by saying that it doesn't matter when it's not viable? As long as the baby's not viable, a woman can have an abortion. Okay. The second thing that this statute does as an exception in the 3rd trimester is that if the mother's life is in danger as a result of the pregnancy, a woman has a right to have an abortion. Okay. Well, that really doesn't change things either, because at least legally, a person has a right to take the life of another human being in order to save themselves, even an innocent person. Besides killing someone who wants to shoot you dead, and you can shoot them in self-defense or understand your ground ideas, even if someone's not causing you intentional harm, but let's say you're being, the house is on fire and the only way you can escape from the house is to trample over other people. It's not a crime to trample over other people because you're trying to save your own life. Saving your own life always justifies the taking of another human being's life. That's our whole history of jurisprudence says that. So if a woman could die if she doesn't have the baby, if she has the baby, it could kill her. Taking the life of the baby in order to save the mother's life is another exception that is legal under this new New York statute. And that's pretty much the same law everywhere. I can't think of any states that says that a woman has to die giving childbirth, that you can never save the woman's life, okay? So that's not a big stretch. However, the 3rd provision in the state of New York causes me to have some concern over this new statute. And that is, if the woman's health could be affected negatively, then she has a right to have an abortion anytime during the 3rd trimester. Now, what does that mean, her health? Does that mean her mental health? Does that mean her physical health? Under the statute, the person who makes that decision is her and her doctor. Now, if someone could, if it's really dangerous and the person could die, let's say she could end up in a coma herself or have a heart attack, it may not kill her. I can understand a person having an abortion under those circumstances in the 3rd trimester when it's a little bit short of her life being endangered. But to allow a doctor to say that, well, it could cause her stress, it could cause her depression, it could cause the woman to be unhappy, or it could cause her boobs to sag, or whatever. Okay? Anything a doctor says is a reason to allow a woman to have an abortion would go under this New York statute. And that seems to be problemsome. It would allow a woman to have an abortion even under the circumstances in which her life isn't in danger and the baby's viable. And that really is a problem, because even though most doctors are ethical and will not follow through in allowing a late-term abortion if the woman's life isn't in danger and it's not really a serious health issue, what's to stop some doctor from just marketing themselves as being basically the king of abortions and just allowing anybody who has enough money to say, yes, for any reason your health is affected so you can have an abortion at any time? That, I think, is a problem with the statute. So even though I agree with most of the statute in New York, I think it needs to be rewritten and changed to actually limit it so that the definition of a serious health concern is actually specified, so that any unethical doctor can't do whatever the hell they want and perform an abortion on demand just because somebody has the money to pay for that abortion. So hopefully you understand what I'm talking about today. I brought in a lot of controversial things, and I hope I explained the situation about Roe v. Wade and people's abortion rights in a way that allows you to understand it. You may disagree, you may agree, but at least you have knowledge. And the only way a person could ever learn how to fight back is by first having knowledge. I will see you next week on Fight Back. Keep doing it, brother.